The centre has told the Supreme Court that the Health Ministry and the Indian Council of Medical Research have come out with guidelines for issuing official document for COVID-related deaths. In an affidavit filed before the top court, the centre also submitted that the Office of the Registrar General of India on September 3rd had issued a circular to provide a medical certificate of cause of death to the next of kin of the deceased. According to the guidelines, COVID-19 cases would be diagnosed through RT-PCR test, molecular test, rapid-antigen test, or clinically determined through investigations at a hospital or an inpatient facility by a treating physician while admitted at the hospital or inpatient facility. Deaths occurring due to poisoning, suicide, homicide, and deaths due to accident, among others, will not be considered as COVID-19 deaths even if COVID-19 is an accompanying condition, the guidelines stated. The Registrar General of India will issue necessary guidelines to chief registrars of all states and union territories in this regard. According to an ICMR study, 95% of deaths takes place within 25 days of a person testing COVID-19 positive, it was mentioned in the guidelines. To make the scope broader and more inclusive, deaths occurring within 30 days from the date of testing or from the date of being clinically determined as COVID-19 case will be treated as deaths due to COVID-19, even if death takes place outside the hospital or inpatient facility, the guidelines stated. However, a COVID-19 patient while admitted at a hospital or inpatient facility and who continued as the same admission beyond 30 days and died subsequently shall be treated as COVID-19 death, according to the guidelines. The guidelines state that in cases where the MCCD is not available or the next of kin of the deceased is not satisfied with the cause of death given in the MCCD and which are not covered by the aforesaid scenarios, states and union territories shall notify a committee at the district level. The committee would consist of an additional district collector, the chief medical officer of health, an additional CMOH or principal or head of department of medicine of a medical college, and a subject expert for issuing of the official document for COVID-19 death. The guidelines also enumerate the procedure to be followed by the committee. The next of kin of the deceased shall submit a petition to the district collector for issuing of the document, it said. The official document for COVID-19 death shall also be communicated to chief registrars of states or union territories and registrar of birth and death who issued the death certificates, one of the guidelines said. The applications for issuing the document and for redressal of grievances shall be disposed of within 30 days of submission of the application or grievance. In its June 30 verdict, the top court had also ordered steps to simplify guidelines for issuance and correction of death certificates or official documents stating the exact cause of death, that is, death due to COVID-19, for enabling dependents to get benefits of welfare schemes. The top court's verdict had come on two separate pleas filed by lawyers Reepa Kansal and Gaurav Kumar Bansal, seeking directions to the centre and the states to provide ₹4 lakh compensation to the families of coronavirus victims as provisioned under the Act. 4 interveners who had lost their family members due to COVID have also moved to the top court through advocate Sumir Sodhi, contending that there cannot be any discrimination in the amounts being paid by different states to family members of those who had succumbed to the deadly infection. News Desk, Kaumudy Global.